Star Hydro Power Limited against the National Transmission and Dispatch Company Limited.
Yes, Mr. Landau. May it please the Court, I'm Toby Landau. I appear for the appellant, NTDC, in this case, along with my learned friend, Mr. Tariq Baloch, MC, and Ms. Catherine Drummond. The respondent, SHPL Star Hydro, is represented by my learned friends Mike McClure, KC, Sarah Parrock, and Joel Halliday.
Yes.
My lords, my lady, can I begin by setting out my intended course? All being well, this is the way I would like to proceed. Firstly, to provide you with an overall overview, big picture, as to why we say the Court of Appeal got it wrong and why we say Star Hydro's proposed approach is wrong.
Yes.
Thereafter, I will proceed to what are identified as issues 1A and 1B in the Statement of Facts and Issues, and that is the test to be applied. And that will require me to go into some detail about the architecture of the New York Convention and its relationship with the courts of the seat.
Yes.
Thereafter, I will then move on to the Lahore application and what is actually happening in Pakistan. After that, I will then move on to what are identified as issues 2A to E and 3 in the Statement of Facts and Issues. And this is on the assumption that the court is not with me, and the court considers that it can consider what we've called merits issues. I'll then address you on what the merits issues are, whether common ground can be part of an award, whether partial recognition and enforcement is possible, whether perceived motivation is relevant, and the question of preemptive applications. And then lastly, I will come to what is at the end of our case, which is if you consider that the arbitration agreement has been breached, whether or not there are strong reasons not to issue an anti-suit.
Yes.
My lords, my lady, in terms of the overview, the first part of this, the Court of Appeal anti-suit injunction order is unprecedented. It is an order stopping New York proceedings abroad. That has never happened before. And it's not happened in England. To our knowledge, it's not happened anywhere around the world. No case has been cited where a New York Convention application has been restrained by an injunction coming from the seat. The injunction is premised exclusively...
What about the decision of His Honour Judge Pelling that is referred to?
Yes, so I'm going to come to that in my overview, because the Court of Appeal was unprecedented, and it's led to Judge Pelling's judgment. So we may now see a flood following the Court of Appeal, but the Court of Appeal was the first time it happened.
Right.
And I'm going to take you to Pelling, because the Pelling judgment, if I call it that, because that shows, in my respectful submission, the danger that we're now in with this new test. Just to be clear, the anti-suit injunction was issued on the basis of an alleged breach of the arbitration agreement only, not vexation and oppression, as being the other possible head. The fundamental error, this is now in my overview, the fundamental error in my respectful submission that the Court of Appeal made and that Star Hydro now make is to extend the well-accepted principle in C versus D to New York Convention. That's the short point. C versus D is a well-established line of authority which allows the English court, as the court of the seat, to restrain any attempt to seek abroad relief that should have been sought in England, like setting aside of the award. What has happened is that principle has now been extended into something totally different, which is the field of recognition and enforcement of awards, New York Convention. And in so doing, as I'm going to show you, the Court of Appeal has gone further, which is now very clear from Judge Pelling's judgment, of actually imposing English law as the law to interpret a multilateral convention for other states. So those are two related points. So what it's saying is that, as far as England is concerned, when it looks and it understands a New York Convention proceeding abroad in another New York Convention contracting state, you do that through the prism of English law, and you only allow what English law would allow in England. Can I now do something which I do with some trepidation as counsel, and that is to paint a big picture of the whole case, knowing that the court will have lots of questions and I might not get to my detailed submissions in order. But the big picture is very important. And having painted the big picture, I then need to flesh out each part of it in stages. So the big picture is this. The New York Convention of 1958 established two distinct types of control over international arbitration. If I can paint a graphic, if you imagine a piece of paper with a line down the middle, the New York Convention established two sides. One side is control by the courts of the seat of arbitration. The other side of the line is control by the country where anybody is seeking recognition and enforcement of an award. So in an arbitration, there will be one seat on one side of the line, and that's the supervisory court. On the other side of the line, as it stands at the moment, there will be 171 possible jurisdictions around the world, because there are 172 contracting states to the New York Convention. So the system that the New York Convention brought into play was that you have control, two types of control. Control and supervision at the seat. That leads up to the rendering of an award and remedies at the seat on the award. The award creditor or the award debtor can take, we'll come to that point later, that award can then be taken to 171 other jurisdictions around the world for recognition and enforcement under the New York Convention. And in that process, the court that's being asked to recognize and enforce also has control. So that's called double control, which we'll see throughout the Travaux, throughout the law and commentary on this area. On each side of that line, there are carefully calibrated provisions as to what each court can do, and they have to sit together. So on the side of the seat court, if it's England, it will be Part 1 of the 1996 Arbitration Act, and I'll take you to those provisions in detail when I get to the detailed submissions. But just to paint the picture, you'll have Section 67, 68, 69, setting aside for jurisdiction issues, procedural irregularity, and in some cases appeal on law. That is then matched by, on the other side of the line, Article 5 of the New York Convention, which lists almost identical grounds. And those are grounds upon which a party can be deployed to resist recognition and enforcement in a particular jurisdiction only. So the grounds are the same, for example, lack of jurisdiction, improper constitution of the tribunal, breach of natural justice, etc. But the exercise on each side of the line is fundamentally different analytically.
And can I just check? Regulation or control by the courts of the seat, does that have a sort of erga omnes effect against all other states? So if the courts of the seat set aside an award, which I think they can do, does that mean the award is no longer valid and can't be enforced? Correct.
That, my Lord, if I may say, is the critical point. Each kind of control is different.
Well, is that proposition indubitably true? I mean, if the award is set aside, then that itself creates a ground for non-enforcement or recognition, doesn't it, under Article 5.1e, I think?
Correct.
It might also, I suppose, create an issue estoppel, which would be a separate basis, which would depend on the law of the state. But apart from that, it doesn't have any sort of inherent erga omnes effect, does it? Those are the two ways in which it might.
So, my Lord,
and even Article 5, 1, it says recognition enforcement may be refused, and there is some law, I think, saying that it may not be. They may decide not to refuse.
My Lord, if I can take those two together, there are some exceptional cases where an award might be set aside at the seat but still enforced.
Yeah.
And we have an example in this country of UKOS, where it was set aside award was set aside by a Russian court, and it was felt that that was corrupt and couldn't be relied upon, wouldn't be recognized in this country, and therefore that set aside wasn't given weight. But just talking about and I'll come to all these examples, but the architecture of the New York Convention is, if I may say, precisely as my Lord Sales has said. The remedy, the control at the courts of the seat, is erga omnes, in the sense that it is a remedy directed at the instrument of the award itself for all purposes. And that means you've rendered an award at the seat can set it aside, the seat can remit it back to the tribunal, the seat can amend it or vary it, and that changes the document, the award itself, for all purposes. So that when, in terms of the structure of the New York Convention, when you take that award around to 171 countries, you'll have to reckon with the fact that it's been set aside at the seat.
Provided they recognise
Yes.
what's been done at the seat.
But, my Lord, that's right, except that this structure, now, again, I'm going to take you to all the authorities on this, the fundamental architecture, this is how double control was put together. The fundamental architecture is premised upon this difference. There will be exceptional cases, and they're exceptional, each one with its own reason, like UKOS, a corrupt court. And there is also a line of authority coming from France where they take a slightly different view about a transnational validity of an award separate from the seat, which is not recognized in this country. But in terms of the architecture, it's erga omnes on one side of that page, but in contrast, if you go to one of the 171 other countries and try and resist recognition and enforcement, it's not an erga omnes remedy. What you're doing is you're simply saying that award should not be given any effect in that jurisdiction. And then the structure of the New York Convention is such that you can then do the same thing in 171 other countries. Each country, under the New York Convention, when it's receiving an award, is simply answering the question, what effect, if any, do we give to this award in this jurisdiction? That's it. And that's how the drafters of the New York Convention managed to construct double control. Otherwise, you would have a complete mess. That's how logically they sit together.
Yeah.
And I'm going to take you through, I don't want to make this sound inter orem, but there's a lot of authority explaining this difference, just how these two sit together.
But I mean, if I may say so, you've explained it very clearly. I mean, do we need to wade through lots and lots of authority other than be aware that it's there and you say it supports what you're saying?
Is there no potential issue estoppel created by the judgment of one enforcing court in another enforcing court, or does that depend on the second enforcing court?
Yeah.
Exactly.
Yeah.
My lady, it's a controversial issue. At the moment, there's nothing in the New York Convention on issue estoppel.
It's a point that's been argued from time to time. I think different results may have been reached.
Very different results. Some countries don't have a concept of issue estoppel. Obviously, civil law countries won't apply it in the same way. Some countries, for example, the Court of Appeal in Singapore, have accepted that you might get an issue estoppel possibly from a decision of the seat court on a recognition and enforcement court. But they've said, the majority in the leading case in Singapore says not an issue estoppel from one recognizing and enforcing court on another recognizing and enforcing court. There's clear material in the travaux of the New York Convention against any issue estoppel because it breaks down the whole structure.
Yes, I was going to say, I mean, the Singaporean approach seems a bit strange, given that the architecture is as you've said.
You can't have this architecture if you then have issue estoppel. And when one looks at the concerns of the contracting states when the New York Convention was drafted, the concern was that double control was essential. The seat is not given primacy. And every state, if it's going to be asked to apply its powers of compulsion to an award, has got to have the right itself to consider whether it wants to recognize and enforce the award. And that's why, when you look at that, there's no room for issue estoppel. So issue estoppel is not in the Convention. It's not about, it's some domestic law, as my Lord has pointed out. There's a debate.
But where then does the obligation of an enforcing court to recognize an amendment or a variation of the award by the seat, where does that derive from?
Because that is the power of the seat to actually, as a supervising court, to rule upon an award within its jurisdiction.
Yes.
And that's reflected in Article 5 of the New York Convention, Article 5(1)(e), which says that one ground for non-recognition and non-enforcement would be a setting aside at the seat.
But even that, you say, it's not, or do you accept that the Convention doesn't make that mandatory?
Correct. Correct. And so that again feeds into this critically important point that you've got to maintain double control, that each recognising and enforcing court's got to have its say. And it does so by its application.
I mean, that's because you're invoking the sovereign power of that jurisdiction to make the award stick.
Can I just add one further?
Why isn't it mandatory? I mean, the logic of the way you've set it up would seem to imply that if you've got decisions of the seat that is ultimately deciding, let's say, the arbitration award is invalid, then, logically, it shouldn't impact, should it, on the enforcing state?
Meaning the enforcing court shouldn't have a discretion?
Yeah.
No, because UKOS is a good example. You will have cases where something perverse has happened.
Yeah.
A local court might be corrupt and has set it aside in manifest...
The general prima facie position is that, that if it's void in the seat, as subsequently decided, or some problem, then that isn't going to be recognised and enforced on the other side of the line, so to speak. And this but you do get occasional cases. Yeah.
And that's why they couldn't say shall, they say may, again, because they want to preserve the authority of that control on that side of the line. And just for your note, I will come to it, there's a decision called Astro, PT First Media and Astro in Singapore, which makes this point in terms, saying because of the erga omnes effect of an award, it's very difficult to see where an award that's been set aside could be recognised and enforced, absent some exceptional circumstance. So...
what's the reference for that?
I'll have to... come to that. Can you find it for me?
Well, if you're going to come to
I'll come to it.
That'll take up time. No.
So, where that leads us, and again, this is, believe it or not, still my overview, where that gets us to is what is the approach of this court in terms of...
Just on Lord Burroughs' question, I mean, presumably, issues of comity and so on come into play with the recognition courts, so that if they can see that the courts of the seat have set aside an award, at least prima facie, they ought to be accepting the effects of the courts of the seat fulfilling their function under the convention and accepting that is the way in which the convention architecture works.
My Lord, the answer is yes, but it's
so
not,
subject to your exceptional
but it's not stated as such in the convention.
Right, okay.
That kind of consideration is left to each contracting state because, as the materials show, when you were dealing with so many different countries with different systems, they obviously legislate at the lowest common denominator, and they leave discretion on many points to each contracting state. We see that in various parts of the convention. So, for example, Article 3 of the New York Convention, which I'll take you to, is the obligation to recognize and enforce awards. But it's made subject expressly to the rules of the country in which the recognition and enforcement is being sought, because they couldn't deal with all the details of the circumstances, the procedure, the way in which it would be done. So it's left to each court. That becomes a very important point for this case, because the Court of Appeal was offended by a number of the aspects of the application in Pakistan, references to things that are common ground, its understanding, which we deny, that this is a preemptive application, it's our approach to partial recognition and enforcement. And it answered those issues by reference to English law. But Article 3, importantly, gives that discretion to the recognising and enforcing court. It's for them to consider how to implement the treaty obligation to recognise and enforce an award. And that's Article 3.
And one can see that once the enforcing court has decided to treat it as a judgment of its own courts, that then brings with it, presumably, all the potential for seizure of goods and corporate insolvency if they refuse to pay. So that does bring with it the sort of the might of the state, which you might think they should be able to decide whether to engage or not.
My lady, that's right. But if I can just be even more precise, there are three stages or three concepts at play. Firstly, recognition of an award. Secondly, enforcement of an award. And thirdly, execution. The New York Convention legislates on the first two, recognition and enforcement. Then, when you've got enforcement, you get to execution, and as my lady says, that's, of course, all the local powers of compulsion and seizure of assets, etc. Recognition means using an award defensively. For example, to raise a res judicata and stop somebody relitigating something. Enforcement is the multitude of ways in which you bring the award into local law and make it effective. Most notably, converting it to a local judgment. And that process of converting it to a local judgment is what we're concerned with here. And that is, even in that, before you get to execution, the Convention gives discretion to the recognizing and enforcing court as to the procedure for that. Will it be preemptive? Will you allow partial, etc.? That's all up to, through Article 3, that's up to the recognizing and enforcing court. With an apology, I wanted to make one point on issue estoppel. Can I go back one step just to complete the point I wanted to make, just to flesh that out? I'd ask the court just to bear in mind, even if one were to look at issue estoppel, which is exceptional and in doubt, very much in doubt, even in this country where we have one first instance decision that has applied an issue estoppel, that's the Diag case, Mr. Justice Eder.
Sorry, the name of the case?
Diag, D-I-A-G. Diag and Czech Republic, I think. That's the only case we've got, and we've got reason to argue why it's wrong. In any event, he recognized you're very unlikely to get an issue estoppel on public policy and arbitrability, which is Article 5.2 of the New York Convention.
Well, those are intrinsically local questions.
Yes, and those are the ones that are in play in this case.
Or primarily, anyway.
Yeah, primarily. Sorry, that was the point I wanted to make before. So those are classically cases for, if you're arguing about Pakistan public policy, that's not going to be an issue estoppel question that's going to bind Pakistan or bind anybody else.
Yeah, almost definitionally, it's not the same issue. So.
Exactly, it's not the same issue. So where this takes us, still in my overview, is what's the approach of the court to an anti-suit injunction? And our test that we have articulated is on the following principle, which is we fully recognize that if you go back to my graphic, the courts of the seat on one side of the line are absolutely entitled to protect their area up to the line. Absolutely entitled, and that's C versus D. Anything that happens abroad, which should have happened on that side of the line in England, could be the subject of an anti-suit injunction. So if you're going for an erga omnes remedy outside from the seat in another country, you've crossed the line. Because that's definitionally, conceptually, that's something you must do at the court of the seat. That's their job. Anything which is going to try and nullify the award itself for all time, for all territories, you can only do at the seat. But what's happened in this case is the remedy that's being sought in Pakistan is not erga omnes, and it couldn't be. Because unlike previous cases involving Pakistan entities which were cited in the Court of Appeal like Atlas, these are old cases under the 1940 Arbitration Act in Pakistan, which is the old legislation, which allows setting aside for misconduct and whatever else. In this case, the application in Pakistan is under the 2011 New York Convention Act in Pakistan. And that means as a matter of Pakistan law, and Pakistan binding Supreme Court authority, which I will show you, we cannot ask the Pakistan court to set aside the award. The only thing we can do in Pakistan is to ask the court to recognize and enforce or not recognize and enforce in Pakistan. That doesn't say anything about how that award would be treated anywhere else. So we say it's squarely on the other side of the line. And the error in this case is to try and expand the supervision of the seat court, England, across that line and interfere in 171 other countries' application and implementation of the New York Convention. If there's a problem with what we're doing in Pakistan, It's for the Pakistan court to reject what we're doing, to dismiss our application. In the same way as if you were to turn the tables and it was a New York Convention application in England, we wouldn't be accepting a foreign court telling us how to apply the New York Convention. We'd apply it according to our understanding.
So if it really were the case that the Pakistan courts were seeking to produce an order intended to have erga omnes effect, it would be a C&D case.
Yes, it would. It would.
An anti-suit
Yes, it
injunction
would.
could lie.
Yes.
But you say it's not that case.
Yes. So, and I should say that we have explained...
Can I just ask about the terminology?
Yes.
Erga omnes, is that a well-established terminology in this area?
It is.
Yeah,
it is. So you see it a lot all the way through. But it is a shorthand, because erga omnes, I mean, it could mean anything. We're using it as a shorthand, and what we mean by it is remedies that are available at the seat that are focused upon the award as an instrument for all purposes, regardless of territory. And that would be a setting aside, could be a remission back to the tribunal, a variation. We have gone through in detail the remedies that we're...
I find it a slightly misleading description because it suggests that it's telling you something about the effect of the court's order, but your point is really about the nature of the remedy that you're seeking from the court.
Yes.
And what effect other courts may give to that is not necessarily concluded by what the Court of the Seat does.
Yes.
So suppose that the arbitral award had said it's 10.36 rupees per kilowatt hour, and then it became apparent there'd been a mistake in the arithmetic, and the court, but the arbitrator refused to deal with it. The Court of the Seat then varies it and says, actually, if you do the maths, it comes out at 10.39 per kilowatt hour, and therefore they vary the order.
Yes.
Now, what is it, I'm still trying to understand, that if the person who wants to enforce it to get the 10.39 takes it to an enforcing court, what is it that stops the other person from saying, no, it should only be 10.36 because that's what the award said, and we ask you to ignore what the Court of Appeal and the court seat said? What I understand you to be saying is there's nothing actually in the convention that prohibits the enforcing court.
Theoretically, an enforcing court would have a discretion, it says may, to take the course that my lady's suggesting and say, well, we're going to disregard the seat court and we'll just enforce the award. But in the main, that's just never been accepted. It's always been accepted, and I know this sounds vague, but it's been accepted always that the seat court is the supervising court, and because Article 5 of the New York Convention, 5.1e, says that a ground for refusing recognition and enforcement is something the seat court has done, and Article 6 of the New York Convention provides a provision that if there's a pending proceeding at the courts of the seat, that would be a basis to stay. So the understanding has always been that the seat court's in control.
No, I understand that. I just want to be absolutely clear in my own mind that you're not saying that there is something in the convention itself which says, contracting states, when you implement this in your domestic law, you must provide that your courts respect a variation made by the seat court.
But all the Travo, all the commentaries, all the...
No, I understand that. You've answered my question. Thank you.
Just to finish off, again, at the general level, we have explained, and I will explain to this court, what we're doing in Pakistan is not a setting aside. We do not seek any relief beyond the question of the effect, if any, to be given in Pakistan. That includes the injunction that we're seeking, which I will explain in detail as to how it works. But the intention for that not to go beyond Pakistan. It's simply a way of enforcing a particular finding in the award. But we've also given an undertaking, offered an undertaking, that if there's any doubt about it, we are prepared to change the relief in any way to make that clear, to undertake that we do not intend any effect beyond Pakistan.
And where do we see that undertaking?
That's in the last part of my written case. And an undertaking that to vary, to say in terms we do not seek a setting aside. And indeed, if the court wanted to go that far, we wouldn't apply for an injunction.
Sorry, just help me with your written case, just so that I can see.
It's the very last page, 92.
Page 92.
You have sort of various layers of retreats, if needed.
I'm not conceding it's a retreat, but clarification.
So these undertakings are not offered conditionally.
No.
They're
Absolutely.
full undertakings to the court on.
And the reason we're doing this is because, if I just speak rather frankly, I had what maybe describes a tough time in the Court of Appeal. The Court of Appeal took a view that we are up to no good in Pakistan. They took a view that we're playing around. All we're trying to do is what has happened in many cases previously, like Atlas, where you're just trying to set aside an award abroad. And there's a long, rich history of that. That all happened in Pakistan and India, by the way, under the 1940 Act.
Well, I can't remember what was under the original prayer, but you were using the word nullity.
Yes, and I'll explain that. There is the word nullification in the prayer, but you can only read it as being nullification for the purposes of arbitrability public policy in Pakistan. That's the full sentence. And I will explain that. But if there is difficulty...
It is a step on the way to a conclusion about recognition and enforcement,
yes.
the way it's phrased, but still,
recognition,
rather
but
unfortunate term.
It is an unfortunate term, absolutely. We've accepted that. And there are, terms are used differently in different jurisdictions with different traditions. And maybe the discipline isn't there as it is here. But anyway, we've undertaken to delete that. The point I'm simply trying to make is that if there's a bad smell about this case, it's unfair. Because we're being absolutely upfront that we are not seeking a setting aside. We are only going under the 2011 Act, asking the Pakistan court to rule upon the effects, if any, in Pakistan. That's it. And that's something which should be left to the Pakistan court as a contracting state in a multilateral treaty. It can't be assessed and prejudged by this court as the supervising court, and in particular, as I'm just about to show you, it can't be done through the prism of English law and the English interpretation in your convention. I think that takes me to the Judge Pelling case, if I can just show you what has now happened since the Court of Appeal judgment.
Right, so we're looking at this is a sort of interorum mission by
it is.
You're saying this shows how wrong it's gone.
It is.
Can I just ask you this? Had you been seeking setting aside?
Yes.
Either partly or wholly?
Yes.
Are you conceding that that would have been unacceptable?
I am.
Right. And you're saying, I mean, was that clear before the Court of Appeal?
I made every attempt to make it clear, my lord. I mean, the Court of Appeal...
Because they're coming at this on the grounds that this is a full-throated attack on the award.
Yes.
And you might say, yeah, because it looked to them as if you were trying to get rid of the award.
Yeah.
At least in some fundamental respects.
Yes. And we're not. And that's something which they did not see. And what they...
Did you give the same undertakings to the Court of Appeal?
We gave the same alternative relief, and that's addressed in the last part of the Court of Appeal judgment.
Right.
And they simply say this is still somehow a setting aside. And the particular point, which I think, my lord, with respect, is so important, was not picked up at all by the Court of Appeal, which is we're going under the 2011 Pakistan Act, not the 1940 Pakistan Act. So as a matter of Pakistan law, it's legally impossible, unless the Pakistan court gets it wrong. We cannot ask for a setting aside under the 2011 Act. And of course, there's a comity question. Does this court assume that the Pakistan court is going to get their law wrong? That is not addressed anywhere by the Court of Appeal.
So just going back to my example a minute where they varied the amount.
Yes.
So do you accept, following on my lord's point, do you accept that if somebody then went to their own enforcing court and said, we want to enforce the unamended number that was in the award and ignore the court of the seat, could an anti-suit injunction properly be issued by the court of the seat to prevent them doing that?
No, certainly not. Because that's a question on, if you forgive me for going back to my graphic,
yes.
It's on one side of the line.
It's on the enforcing side.
It's on the enforcing side. But the minute that question creeps over the line, then yes.
But it wouldn't be creeping over the line to try and ignore this...
Because because the question is, what are you asking for? And if you're only asking for a determination as to the effects, if any, in that jurisdiction, that is the preserve of that court. But if you're asking for more than that, which is take the arbitration award as an instrument for all purposes, then you've crossed the line. And that's a very clear, easy line. And it's the essence of double control. That's the architecture of the New York Convention, which was known to the drafters. All these issues, they were addressed at the time, because there was always a question, how do you match two types of control? How do you allow them to live together? And in the course of the drafting of the New York Convention, there were proposals that were made to say everything should be the courts of the seat. They should have the final say, and that was rejected. Then maybe it could just be the enforcement court, obviously rejected. And so the balance that was struck in the end is the line that I have depicted. Can I make my interim submission?
Sorry, just before you get there, I'm sorry to interrupt.
Yes, no, not at all.
But if you go back to page 150 of the electronic bundle and the Court of Appeal decision, paragraphs 67 and 68, it's pretty clear that Lord Justice Phillips did not see the undertakings that were then being offered as going so far as to rule out the possibility of seeking nullification of the award.
Yes.
So you were offering different undertakings.
We're offering more undertakings now, but the core of it, the amendment, is the same.
Right.
That's I think the second or third alternative we've got in our written case.
Right, but his last sentence clearly, this word nullifying was clearly very important.
Nullifying doesn't appear in the wording of 67.
No, it doesn't.
So the part of that undertaking was to take out the word nullifying.
But it still says that Star Hydro will be permanently restrained from issuing any invoices.
Yes, and that is within Pakistan. And if that needs to be clarified, we'd say within Pakistan. And I will explain why that is, because again, that's enforcement of a particular declaration in the award. But it's with no intention whatsoever for that to go beyond the territory of Pakistan. It's simply what effect, if any, in Pakistan will this award be given.
So you say the last sentence of 68 is just fundamentally incorrect?
Yes. And it's incorrect as a matter of Pakistan law, because the 2011 Act doesn't allow for that. I have another, if I may say, I have another objection to that last part of 68, which is what the Court of Appeal has done here is to look at any other relief and to assume bad faith on the part of both us and the Pakistan court. Any other relief is something which is standard boilerplate.
Yeah.
I think what the Court of Appeal is saying here is that we can't be trusted, and nor can the Pakistan court be trusted, because any other relief might allow them to do something else. That's no way to proceed with respect to the Court of Appeal. You can't, and especially in the context of a multilateral convention where the UK has agreed to Pakistan being a competent authority, as well as all the other 171 countries. We've agreed in a treaty that our fellow contracting states will implement and apply this treaty. So the Court of Appeal was absolutely wrong to say, well, we can't allow this because that phrase might allow the Pakistan court to breach the New York Convention. And again, there's no evidence before the Court of Appeal. There's nothing referred to the 2011 Act. How could it do it? And anyway, how can we assume that?
And it would be, well, in my experience, the sort of standard phrase that you'd use here as well. That there are
just stick it in at the end in case, so that it comes out at the hearing you've forgotten something. Yeah. It doesn't usually do you much good then anyway.
Exactly.
Because you should have put it in there more specifically.
Exactly.
Okay, interorum.
It's not entirely interorum, because you're presumably asking us to hold that this case was wrongly decided.
Because...
Yeah, but yes. I think you're showing it, as I understand, you're showing it to us to say this it shows how things can go, how far things can go wrong.
Firstly that, but also it shows Judge Pelling the way that he clearly sets out what he sees as the impacts, the analysis of the Court of Appeal, how he's getting there. And that's important because it's now stretching C versus D. C versus D is this seminal linchpin case. That's the one upon which we have Atlas and Enker and many other cases rely upon to say that the seat court has the ability to enjoin anybody trying to set aside abroad. And what now is being done is the wording of C and D is being stretched, and that's where this is leading to all sorts of problems. And that's clear from Judge Pelling's case. So if I can just go to that. The case is Integra, Petrochemicals and BASF. It starts in the bundle at 1869. This came out September 2025, so pretty soon after the Court of Appeal judgment. I'll just quickly paint the facts. It was a dispute as to whether or not a sale of biomethanol had been concluded. That was the question. There was an arbitration in London. A sole arbitrator held the contract had been concluded. And that meant that the party called Integra was successful. BASF was saying there was no contract, and they could have challenged that under Section 67 and 68 before the London court as the court of the seat. But they didn't. They didn't challenge it for a number of reasons to do with funding and various other things. But all one needs to know is they didn't challenge it. And time ran out so that they were no longer able to challenge it in London. So what then happened was BASF commenced proceedings in Germany under the New York Convention. And we see that at page 1872. Paragraph 8. And if I just read the beginning of that, on the 4th of June, 2025, BASF commenced the German proceedings. The document by which the German proceedings were commenced is entitled Application for Declaration of Non-Recognition of the Foreign Arbitral Award. So this is what's called a preemptive application by an award debtor under the New York Convention to the German court as a contracting state under the New York Convention to not recognize in advance of any application being made by the award creditor. So there's no application to recognize and enforce by Integra, but this is started by BASF to say you can't recognize it. It's common ground, as we see from paragraph 9, that preemptive application is acceptable under German law. So the Court of Appeal in our case said you cannot have preemption under the New York Convention, but that's just not true. Many countries, a number which we've cited in our written case, do allow it. And that's up to them. That's the way that they implement the New York Convention. And that goes back.
I mean, for what it's worth, we might do that here.
Yes.
Because it's just
Absolutely.
an aspect of the width of our declaratory relief jurisdiction.
Yes. And under Article 3 of the New York Convention, you have an express reference to the rules of the country where recognition and enforcement is sought.
Rules of procedure.
Rules of procedure.
This is procedure.
Yes.
Yeah.
Yes. And we've got a commentary by Shearer we've put in, which says that in terms that a good example of the rules of procedure in Article 3 would be whether or not to allow preemptive applications. Again, I can give you that reference when we get to that. So if one then goes to 1873, the ground which was being deployed in Germany was, you see this at the bottom half of that page, beginning at page 73, BASF summarizes the merits of its application. And if you would just scan through that, what they were relying upon was Article 5.1a of the New York Convention to say that there was no jurisdiction because there was no agreement concluded. So it's the same ground that they could have brought under Section 67 at the seat, but they didn't. At page...
Well, it's the sort of case where you can potentially argue the same point time and time again in lots of different places.
Correct.
Where, first of all, the arbitrator decides whether he's got jurisdiction, and then every other court decides whether he did or didn't.
And it sounds cumbersome, and it sounds inconvenient, but that's the structure of the architecture of your convention because of double control.
It's a recognition of, well, the sovereignty of the receiving state, that they're entitled to apply their own filters as well.
Absolutely. And again, going back to the Travo, those states would not necessarily have agreed to apply their sovereign powers of compulsion unless they have control.
Control, yeah. So it's just fundamental. You say fundamental to the bargain under the convention.
It's fundamental. And I'm just going to take that just one increment further.
Yeah.
Article 5 is split up into two groups of defences, 5.1a and 5.1 and 5.2.
Could you give us the reference just so we can follow the point that you're making?
3841. Sorry, this is a slight diversion, but it's relevant.
Yes.
So Article 5 is in two groups of defences, 5.1 and 5.2. The point that my Lord has put to me about the sovereign discretion is even more heightened when it gets to 5.2, which is relevant in this case, and that's on arbitrability and public policy. Because that is so sensitive, that is something which the state, the recognising and enforcing court can raise of its own motion, sua sponte. So it's not dependent upon any party raising it, whether it's award debtor or award creditor, anybody.
So, and where does one see that in Article 5?
5.2, if you look at the chapeau of 5.2 and compare it to 5.1. 3843. Thank you. 3843.
I think that is an inference drawn from the fact that it doesn't have the words about the request of the party against whom it is invoked.
Yes.
Right.
Yes. Thank you. Can I go back to the BASF case? So at page 1875, actually, the discussion starts at 1874. So sorry, just to complete the facts. So this application is brought in Germany, and Integra then approached the English court for an anti-suit injunction to stop this happening under the New York Convention. At the bottom of page 1874, we get the heading discussion. Going over to 1875, if I can just pick up about 7 or so lines from the top. The judge said, as a matter of English law, if the court has that, as a matter of English law, by agreeing to English law as the curial law of the arbitration, the parties agreed that any challenge to the award was to be made in the English courts, save to the extent otherwise permitted by English law. And that is the crux of Merlin and Friends case, and it's the crux of the Court of Appeal reasoning. It's the statement in C and D that any challenge to the award was to be made in the English courts, save to the extent otherwise permitted by English law. And that, what I'm going to show you, is a misreading of C versus D. As it happens, C versus D was not about New York Convention. It was only about that side of the line, which is the preserve of the courts of the seat. And I'm going to show you, the New York Convention was expressly carved out of C versus D, both at first instance and Court of Appeal. They made reference to the New York Convention and said, we're not covering that.
There's a slight wrinkle here, which is that actually the arbitration agreement is agreed to be governed by Pakistan law. It therefore seems to me that strictly the question of what the parties agreed to do should be determined in accordance with Pakistan law, although, as I don't think we've got any evidence, we're probably assuming it's the same as English law.
Yes. But the question here is not just within to be characterized as what was agreed in the arbitration agreement. It's also the English courts as the lex fori, its interpretation and application of a convention, what its approach is. Because, as if we just go down, just to the bottom of page 1875, where we are, there's a paragraph beginning, this principle has no impact. If you just go down 3 lines, it says, 4 lines, I qualify this proposition by reference to English law because by choosing London as the seat of the arbitration, the parties may be taken to have agreed that proceedings on the award should be only those permitted by English law.
Well, what they should be taken to have agreed is a matter of construction of their agreement.
Correct. Which
must be governed by the law of the arbitration agreement.
Correct. Oh, that's correct. Then, if I can take you, please, to page 1877, at paragraph 15. As a matter of English law, therefore, the starting point is that any challenge, I put emphasis on those words because that's important for my learned friend, any challenge to an award can only be those permitted by the Arbitration Act 1996, and then they cite the Court of Appeal in this case, Judge Pelling cites. And then just dropping down about 5 lines, there's a sentence beginning, to the general principle identified above, there is an exception which enables a party to an arbitration seated in England to challenge awards in the circumstances permitted by the New York Convention, but only to the extent recognized by English law for the reasons identified by Longmore. With all due respect to the learned judge, that is a bizarre proposition. It's not in C versus D anywhere. And what was then found was that by the learned judge was that English law does not allow preemptive applications. That's an application by an award debtor under the New York Convention. And therefore, for that reason alone, the German proceedings were impermissible. But Germany, for more than 60 years, has allowed preemptive applications under the New York Convention. So what's happening here is, because of the Court of Appeals approach, the learned judge says, when you're dealing with a New York Convention application, you interpret the New York Convention by the law of the seat, England. And that allows the English court, albeit indirectly, to tell Germany it can't do what it's always done with its implementation of the New York Convention. And that approach answered what we've called the merits issues before the Court of Appeal in this case. The Court of Appeal, as Starr does now, addresses each of the points which they don't like in the Lahore proceedings by reference to English law and English practice, like, is this partial recognition enforcement? Can you sever the award? Is it preemptive? Can issues of common ground be recognized and enforced? Is motivation relevant? Now, all those questions are now, through the Court of Appeal, subject to English law. The court says, English law says this, and therefore what you're doing in Pakistan is improper. And therefore...
So that was the jump that you say was made in... Well, they think there were two jumps. First, moving it, allowing anti-suit injunctions when they're not seeking as erga omnes as it gets under the New York Convention. And then the other is not allowing relief, not allowing someone to apply for relief in an enforcing court if that relief would not be available.
Correct.
If you were trying to enforce a foreign award in England.
Correct. We do say, although those are two separate issues, they're springing from the same source, which is overly expanding the role of the supervisory court.
Yeah.
And that totally undermines the New York Convention architecture and double control.
I'm not aware it's ever been suggested here that when somebody's trying to enforce or recognise an arbitration award made in a foreign country, that we should be looking at the law of that country and deciding whether they would recognise or enforce it to decide whether we should here.
Well, my lord, I was going to address you in some detail on that because this would represent a total sea change for the English court. Never, in my knowledge, I've argued a number of these, never in a New York Convention application has the English court looked at the law of the seat to interpret and implement.
I don't think so.
And it would change results that we know. I mean, I can give you some examples. Kebabji and Koot food. Kebabji was a case where the question was whether or not a general choice of law in a contract should be taken as a law governing arbitration agreement. The English court took a view on that in the context of a New York Convention application for recognition and enforcement and decided that it did apply to the arbitration agreement such that a particular party was held not a party to the arbitration agreement. Perhaps in a long, rich historical tradition, The French courts disagreed with the English court. And the French court is the court of the seat. So England having taken that view under the New York Convention, the French court hears an application at the seat as supervising court, and they say, no, a general choice of law governing an arbitration agreement doesn't extend to the arbitration agreement. The arbitration agreement is governed by the law of the seat, the forum. And so they apply a different law and say that party is a party. Now, assume for now that France has an anti-suit injunction jurisdiction. In this scenario, according to the Court of Appeal, the French court could enjoin the English court from the determination that it made in Kebabchi under the New York Convention, because it could be characterized as a challenge to the award in England, which would not be acceptable in France. That would be an extraordinary result. But that's what the Court of Appeal test does. That's what Starr's test does. Whereas, I think the term is unfortunate, but what we've called the erga omnes test, the test that we have articulated is the one that preserves the essential architecture of the New York Convention and is absolutely consistent with C versus D. And that is, as long as the English court is only concerned with the effect of the award in England, it's fine.
But how do you tell whether it's only concerned with the effect of the award in England?
That is something which requires the court to have a look and take a view. And what the Court of Appeal, we had, in fairness, we had alternative cases in the courts below, where one of our cases was a little bit more extreme to say, look, if it's New York Convention, it says it, you can't even look. And we accept that's not right. It's not a silver bullet or labeling question. It is a question of substance over form, where the English court can take a view. And the English court's used to doing that, because in C versus D, that's what it does. All the cases following C versus D look at what is being applied for abroad. They do that already.
So if, for example, in Pakistan you were seeking relief to say Starr should not, to injunct Starr from issuing invoices in any country or trying to sue on those invoices in any country, then we could look at that and say that is going further than
Absolutely.
we can.
Yes.
But what about, one more question, in my earlier example where the court of the, where there's one side thinks there's been an error in the computation of the amount, suppose there's no application in the seat to amend the order, but when somebody tries to enforce the order in a different country, in that country they say, no, there was this error, actually the award needs to be varied to change the figure. Where would that, would we be able to issue an anti-suit injunction to stop them doing that?
It would depend on whether what's being asked is with the intention of an effect beyond that territory.
What you're looking at is what is the remedy that they're seeking. Is it enforcement, non-enforcement, recognition, non-recognition, or does it go beyond that?
Yes.
And then I think you're saying that we should look at what is the jurisdiction of the court being invoked, because if it's a jurisdiction to recognise or enforce, then that tells you the most that you could get there.
Yes, and that's why the Court of Appeal was very motivated, driven by the Atlas case. The Atlas case, can I say, from my point of view, for what it's worth, is unfortunate because it involved my client. Not me, but my client some years ago. And my client in the Atlas case went for a London arbitration, went to Pakistan under the 1940 Arbitration Act and asked the Pakistan court to set aside the award, not having asked the Sikh court to do that. The decision, it was unfortunate for me because Lord Justice Phillips sat on that case and sat on the appeal in this case. And he obviously thought, you're playing games, you're doing what you've done before. But here's the key difference which my Lord has identified. Unlike Atlas, this was the 2011 Act. And to show that, we have put in the bundle the application that was made in Pakistan in the Atlas case. I'll just give you the reference. When you read through that application in the Atlas case, there are pages and pages of submissions to the Pakistan court on why the New York Convention has no application in that case, why the award should be treated as a domestic award in Pakistan, and therefore set aside for all time. It's page 505 in the bundle. So we've put that in to make the point that if you compare that to the Lahore application in this case, it's only under the 2011 Act. It's only framed in terms of your convention. And therefore, it's a totally different exercise. And of course, it engages binding Pakistan Supreme Court authority, in particular the case called Taisai, T-A-I-S-E-I, which again, I'll give you the citation in a moment. Taisai is the leading authority of the Supreme Court in Pakistan, which talks about the limits of the court's role under the New York Convention. It talks about minimal intervention. And
I think under the 2011 Act as well. You said under the New York Convention.
Yes.
That's under the 2011 Act as well.
Yes.
All right.
And so that's why it's not an Atlas case. And that's why, going back to my lady's question, it's perfectly possible for a court to take a view.
Do you have a page reference just for Taisai?
Yeah, Taisai is 2939, tab 123. I don't know if tabs are helpful.
No, they're not.
Yeah, 2939.
Thank you very much.
So, after exhaustive and exhausting submissions, I've reached the end of my overview. My lords, my lady, can I indicate where I was going to go, and we'll just see what perhaps may be of assistance. Having set out my graphic, what I had intended to do was just to show you some materials to make good the two different sides. Then to show you some materials on double control and how this concept, the two were married when the convention was drafted. That would then take me to the fact that this is all part of what we say is the arbitration agreement in this case. And that's important because you're dealing with an anti-suit injunction premised upon an alleged breach of the arbitration agreement, not vexation and oppression, which may raise other issues. So that's why it's relevant, because we say, frankly, you can't breach the arbitration agreement by going under the New York Convention if you've decided to locate your arbitration in a New York Convention contracting state. That's where I was headed, and then to look at the test itself that we are proposing and the particular objections that are being made against it. Then I was going to go to the Lahore proceedings in more detail.
It does seem rather counterintuitive that you describe this as process as rather cumbersome and inconvenient, that you have this convention, you get this award. You would have thought that the point of having the convention is that you can then go and enforce it quite straightforwardly without them being able to pop up and challenge it wherever you go. But you say, well, no. We've got 171 countries, they're a very mixed bag, this is all they were prepared to agree to.
My lady, perhaps one can think about this in context. You think about the difficulty that the world has had in concluding a judgments convention, and the sensitivity even with receiving a judgment from a court of one country into another. Now think about receiving an award from some unknown tribunal, who knows who they are, private individuals appointed to decide something, and you're asking contracting states on a summary basis to recognize and enforce by making it a local judgment of theirs to which they will apply their sovereign powers. I mean, that is, you're asking a lot. And that's why the Travaux are full of this debate about control. And one should just also get the context here. Before the New York Convention, there was the 1927 Geneva Convention. That was the forerunner. That was a very problematic convention. What it did for arbitration agreements and arbitration awards, in this case, is it said you could take your arbitration award around the world and get recognition and enforcement, but there was a requirement of what was called double exequatur. Double exequatur meant if you were the award creditor, your burden was to get enforcement and recognition at the seat first, or prove that that would be possible in order to get recognition and enforcement in any other country. That just didn't work as a system. It was cumbersome and it was complicated. So the revolution that is hailed with the New York Convention in 1958 was it got rid of double exequatur. So what you're doing by that is you are immediately taking away the primacy of the seat, which used to exist under the Geneva Convention, and you're giving instead control to all the other states. The only way that could function and would be acceptable is double control.
I think it's fair to say, though, that the point my lady raised is a matter of debate in the international, what you might call the international arbitration community, isn't it?
Yes.
And, for example, there's an article by Chief Justice Menon in Singapore, which is often produced, where he's suggesting that there should be issue estoppels recognised for judgments under Article 5.1, I think, and then the Article 5.2 should be left to sort of local. So he's trying to make proposals for a more cohesive international regime. So this is sort of an open issue, but it doesn't affect this. It doesn't affect the substance of what you're saying.
It doesn't. And my Lord, if I just add, Chief Justice Menon authored the India case in the Court of Appeal
in Singapore.
2023.
Right.
That was the case you told us about.
Yeah.
Which.
And so he's making a distinction between an issue estoppel arising from a determination from the seat court and one arising from a determination of a recognition enforcement court. He said there was a dissent in that case, which was Lord Mance. But Chief Justice Menon said that there were grounds not, he doubted that and that was the difference. He said it wouldn't arise from a recognition enforcement court. This is page 3257. He would only be contemplating it from the seat court. And that tells you a lot about the different exercise that each court is doing, and goes back to my graphic. But in any event, as my Lord has pointed out, it doesn't affect anything in my submissions, because it's not New York Convention architecture, it's not the treaty itself. It's a debate under local law, domestic law, as to whether or not if they have issue estoppel, whether or not that might be a technique that they might use sometimes, and it's doubted by many people. If there was an appetite, perhaps later, I'll show you a portion of the travaux préparatoires of the New York Convention, which has not been cited by Mr. Justice Eder in Diag and Czech Republic. It wasn't cited even by the Singapore court, and it's flatly contradictory to the idea of an estoppel between seat and recognition enforcement court. Because when the New York Convention was being drafted, there were various models that were raised as possibilities, and one of them would have limited the say of each recognizing and enforcing court, and that was rejected.
Yes.
My Lords, my Lady, we have a break in 5 minutes, I think, a 10-minute break for the transcript.
Yes.
I don't know whether...
We seem to have long breaks for transcript writers, and since it's been agreed, we will honour it. But I ought to say, usually we don't have breaks for transcript.
I'd rather not. But it's a 10-minute break scheduled.
In the past, Patrick has said we don't have them because they can, if they need to catch up, they can see it on YouTube.
Yeah. Well, I'd rather press on.
Yeah. Why don't we do
Yeah.
that?
We also have an AI generated transcript
Exactly.
ourselves.
Yeah.
So I think the preference, unless my colleagues indicate otherwise, the preference from the benches, let's just keep going.
I'm grateful. So I've indicated where I was headed, but I think I can shortcut some of the steps.
Yes.
So my next step now is to just flesh out each side of my graphic. And that is, what is the nature of the powers at the seat court, just to show you some materials.
Yes.
And then on the other side, in contrast, recognition and enforcement.
So we're going to start with the seat.
Start with the
seat.
seat.
Where you're taking us now. Okay.
Can I ask you to look at the 1996 Act, just to show the English position? That's from page 947. So this is where we find the powers of the seat court for England. And the seat court, of course, will have powers before and during the arbitration. This is all in part 1 of the Act. Sorry, just to step back. The Act is made up of several parts. Part 1 is the court acting as a supervising court, where the seat is in England, Wales, or Northern Ireland. Part 3 is New York Convention, and that is the English court acting as a recognising and enforcing court under the New York Convention. That's the split. Under Part 1, there are a host of provisions which show different things that the English court will do in its supervisory function. And they can be broken down into powers before and during the arbitration. So I just list some sections as an example. I know the court's familiar with it. Such as sections 12, extensions of time, section 24, removal of arbitrators, section 32, determinations of jurisdiction issues, section 44, court powers in support, etc. Then there's the second category, which is relevant for our purposes, and that's post-award. Once an award has been rendered in a London seat, the supervisory powers are contained, the primary ones, there are some ancillary ones. The primary ones are in section 66 to 69. So starting at 66 is recognition and enforcement, which is a domestic process for English awards, but it can be used for New York Convention awards as well. And we see that in section 104 of the Act.
So that's just to draw an arbitral award into
Correct.
the domestic
Correct.
English jurisdiction.
That's it. Then we've got section 67, that's at page 981. That is...
Or did you say 981?
981, and that's challenging the award on grounds of substantive jurisdiction. And importantly, you'll see the remedies that are available. 67.3, on an application under this section, the court may by order confirm the award, vary the award, remit the award to the tribunal in whole or in part for reconsideration, set aside the award in whole or in part, or declare the award to be of no effect in whole or in part. So those are, using the unhappy term, forgive me, those are erga omnes remedies. Those are all going to the award as a legal instrument.
Yeah, that's the more accurate way of putting it, isn't
Yes.
it?
Yes, regardless of territory. One needs a neater encapsulation of that.
Preferably in Latin.
Preferably. I mean, it allows someone to charge more if it's Latin.
Right. So that the effect of that is that you're not saying there's anything in the convention which stops an enforcing court dealing with an application that should be, that's asking for that relief, but we would issue an anti-suit injunction to stop that if somebody asked us to.
Correct. But sorry, my lady, just to be clearer, there's nothing in the award. Sorry, there's nothing in the New York Convention which provides for this. The New York Convention, the only remedies we're talking about in the New York Convention are Article 5 and Article 6, and that's grounds for resisting recognition and enforcement. That's all. There's no reference in the New York Convention to setting aside, remission, variation. That's just not within. That's just not within the powers on that side of the line in my graphic of a recognizing and enforcing court.
I mean, in a sense, perhaps this does go to the erga omnes point. If England is the seat of the arbitration and an English court issues an order pursuant to section 67 saying something has gone badly wrong, the award is nullity, that doesn't, as I understand what you're saying, it doesn't strictly bind the court in a receiving state, where the person who's got the award, they still have the award, can take it to the receiving state and say, enforce this. I mean, the receiving state would have to look at how they should react to what the English courts have done, but they're not strictly bound by what the English... I'm summarising it correctly.
And correctly, I say. Okay. And we get that from the use of the word may in Article 5 of the New York Convention. So may refuse recognition and enforcement on the following grounds. And as I said before, we have some, these are exceptional, but there are some examples which we have, for example, like UKOS. In UKOS, it was felt that the Russian court at the seat had not acted fairly or was corrupt.
But we would issue an anti-suit injunction to stop somebody going to an enforcing court, asking the enforcing court to ignore what the seat court has said.
No. my lady, we would only, in my submission, the English court can enjoin foreign proceedings if they're on that side of the line.
Yes, yes.
So if they're trying to do in the foreign court what could be done under 67, so if they're trying to set aside the award.
Exactly.
But in the example given, they wouldn't be trying to do that because it would just be the receiving court looking at an award, conscious in the example that the seat court has said some things about that award, but the seat court doesn't have the power to rip up the award and say it doesn't exist at all.
Yep. So what I'm doing by showing you these provisions is to really flesh out that side of the line as to what is the supervisory function.
And when you say fleshed out, I mean, you're looking, here we are looking at it through the prism of English law, which but you're using that as an illustrative example of the way this system...
This is an international standard. And the reason I say that with such sudden confidence is... No, it's nothing to do with me. The reason it's an international standard is it's based upon the model law. So there is something called the UNCITRAL model law on international commercial arbitration, which dates from 1985. And that is the international standard for national arbitration laws. That is now, it was set up as a model to be used by countries all around the world to reform their arbitration law. It's in the bundle at 3857. This is a very important document. What's happened now is, I don't have the figure in the top of my head, but it's a very large number of countries worldwide have adopted it, or have, like England, Wales, and Northern Ireland, have been heavily influenced by it and implemented its main features. And what we see here is in the UNCITRAL model law. If you'd like to just allow me just another step on this. I'm going to come back in a moment to the UNCITRAL model law because New York Convention was 1958, and it set up this regime for that other side of the line for recognition and enforcement. In 1985, the UN then decided to have a model for national arbitration laws, and they included two provisions in that model, Article 34 and Article 36. Article 34 of the model is what we're looking at here, setting aside at the seat. Article 36 of the model is New York Convention. For various reasons, they thought that should also be in the law because not every country had a regime for recognition and enforcement. So that immediately raised the question of double control. You've got one model law, and you've got Article 34, which has got these provisions. Then you've got Article 36, which is New York Convention, recognition and enforcement. How do they sit together? And we see in the... and the model, sorry, I should say, that the interesting thing about it, exactly, and be reminded, is that the grounds in Article 34 for setting aside an award are identical to Article 36. It's the same grounds. And it's the same grounds were copied from Article 5 of the New York Convention. And when we look at the travo of the model law, I'll show you just two references when we get to that in a minute. It's again the same double control, which is these look the same. They both look, in the words of my learned friend, they look like a challenge of the award abroad, or anywhere, a challenge to the award, or an attack on the award. That's the language that's being used. But they are for totally analytically different purposes. Article 34 is on one side of the line. It's the seat. It's setting aside.
I mean, strictly, it's an attack on the enforceability of the award as received in the receiving state.
Correct. That's the distinction.
It's just that to attack enforceability, one reason for doing so may be that you say to the court in the receiving state, this award should never have been made for particular reasons. Something's gone badly wrong with the award.
Correct.
But it's still, that doesn't, you're saying, as I understand it, that doesn't change the fundamental nature of what's happening in the courts of the receiving state, which is they're just looking at enforceability in their jurisdiction.
Correct.
So are you saying that UNCITRAL goes further or doesn't go further than
same. Exactly the same. Exactly the same principle. And again, that wouldn't work, the analysis, the way that the UNCITRAL model will work, it wouldn't work on my learned friend's case or the Court of Appeal, because you've then got this idea that anything which can be construed as a challenge or an attack can be restrained by the seat. And that misses this distinction. That's sort of, in a sense, the core error that's being made here. The distinction between my graphic is being ignored, and there's this higher general term being used of challenge or attack. The idea that the seat can protect from any challenge or attack. And on that point, I wonder whether I can just quickly turn up my own friend's written case and just show you the way it's been put by them. It's about...
just so that I've got it in my head, I mean, you're saying that there is a congruence between the New York Convention, the model law, and our Arbitration Act, which I think you said was based on the model law. And you say, if you look at all these things, they're reflecting what you have told us is your graphic.
Correct.
Okay.
You'll see in the DAC report, which was the Departmental Advisory Committee report that was published alongside when the 1996 Arbitration Act was concluded and passed. It's all about the UNCITRAL model law.
Right.
It's an implementation of the model law.
Yeah. Sorry, I interrupted you. Where did you want to go?
I'm coming away from the English Act, but I'm coming back to it in a minute. I just wanted to finish this point about we're talking about attack and challenge. If I could ask the court just to turn up my learned friend's written case at paragraph 41A, which is page 109 of the key documents bundle. Just look at the breadth of the test that they're seeking. You have that.
Sorry, what paragraph?
Paragraph 41A.
41A.
Yeah. (41A) The English court's supervisory jurisdiction is not limited to restraining proceedings that must be brought under sections 67 to 69 of the 1996 Act. Rather, the English court's supervisory jurisdiction allows it to restrain any challenges to the award that are not permitted by English law, C, C, and D, and ENCA. An attack or challenge to an award is more than seeking set-aside or erga omnes relief in the foreign jurisdiction. It is seeking anything that could undermine any part of an award, such as also injuncting a party from enforcing the award or seeking in other proceedings declarations contrary. Now, that is an incredibly broad proposition which would destroy this architecture. You could say that, going back to the UNCITRAL model law, you could say Article 36 is an attack, it's a challenge. You're undermining the award.
And that's why you're emphasising, but the grounds in Article 36 are the same as in Article 34.
That's the point. But they're there for a different purpose. And that's the distinction the Court of Appeal missed.
Presumably it's got an extra ground in 36 about the award being set aside under Article 34, as it were.
Yes. Yes, it does. So I said it's the same, but of course it's the same grounds. It's got that extra one because it's replicated Article 5 in your convention.
Yeah.
Yeah. My lords, I just took a slight sidetrack. Can I come back to where I am?
Yes.
Which is just to finish off for the completeness. I'm talking still about what are the powers of the supervisory court. I've taken you to section 67. I just want to complete this by the full armoury that the English court has, which is consistent with the model law. English court also has section 68, which is on page 983, and that's challenging the award for serious irregularity. So 67 was jurisdiction problems. 68 is procedural irregularity. And here, again, these are the same points that are covered by Article 5 of the New York Convention, but for a different purpose. And if you look at 68.3, you can see the remedies that are available. If there is shown to be serious irregularity affecting the tribunal, the proceedings or the award, the court may remit the award to the tribunal in whole or in part for reconsideration, set the award aside in whole or in part, or declare the award to be of no effect in whole or in part. And again, that's all erga omnes. It's not about territorial recognition enforcement. Just to complete this, we do have one oddity in English law, which is not UNCITRAL model law, and that's section 69, which is there for historical reasons, and that's a possibility of an appeal on a point of law, which I think we're one of the last remaining countries to have that. But that is a non-mandatory provision which can be contracted out of, and in this case it was contracted out of by the application of the LCIA arbitration rules, so it's not relevant in this case. but it's relevant in terms of what is the armoury available at the seat.
Sorry, did you say that lots of countries do have it, or
No, they
that
don't.
they don't?
They don't. The idea, we have it for, this is a whole other topic, we have it because we've had it for many, a long time.
Yes. But
most countries, the Australian model law doesn't have it. The idea is if you go to arbitration, there's no appeal at all. Because of our...
No, I understand.
So we kept it, but we kept it on the basis that it's non-mandatory. You can contract out of it at any stage. And if you apply the LCIA rules, as in this case, it's got in it, the rules say you can't appeal, so you've contracted out. Now, I had threatened the court with materials on the erga omnes effect. I can show you some of them if it's helpful, or I can just give you the references. I mean, there are...
Well, if you could, I don't know, show us your prime reference, and just to make the point so we've got it in mind, and then perhaps you can just supply us with some references that we...
Yes, well, so it's explained well in the starting point, Redfern and Hunter, which is one of the main textbooks. That is an excerpt, starts at 4474.
So you're now talking about commentaries that have made...
Well, I'll show you one commentary, and then I'll show you some decisions that refer to it.
All right.
So this is sort of the classic textbook on international commercial arbitration, and at 4475, this is paragraph 10.05 at the bottom of the page. It is right at the bottom. It is important at the outset to make a clear distinction between actions to challenge an award and opposition to actions seeking to recognise and enforce an award. A challenge to an award usually takes place in the courts of the seat of the arbitration. It is an attempt by the losing party to invalidate the award on the basis of the statutory grounds available under the law of the seat. In contrast, actions seeking to recognise and enforce an award, which are fully discussed in the next chapter, may take place in any jurisdiction signatory to the New York Convention, or one that has adopted the relevant provisions of the model law. In such actions, the party against whom recognition and enforcement is sought may rely on the limited exceptions contained in Article 5 of the New York Convention or the corresponding provisions of the model law to seek to block enforcement. And then the next paragraph, purpose of challenge. The purpose of challenging an award before a national court at the seat of arbitration is to have that court declare all or part of the award null and void. If an award is set aside or annulled by the relevant court, it will usually be treated as invalid and accordingly unenforceable, not only by the courts of the seat of arbitration, but also by national courts elsewhere. This is because, under both the New York Convention and the model law, a competent court may refuse to grant recognition and enforcement of an award that has been set aside by a court of the seat of arbitration. It's important to note that following complete annulment, the claimant can recommence proceedings because the award simply doesn't exist. And that last, just pausing there, that last point is an illustration of this. If an award is set aside, it doesn't exist anymore, so you could commence a new arbitration. If an award is not recognised or enforced in a territory, it still exists. So you can't recommence another arbitration. And that's why I'm focusing on remedies that go to the instrument itself as a legal instrument, rather than its effect in a particular territory. There's one more commentary I'll just briefly show you, 4412, which elaborates on this point that I've just made. 4412 is an article by Professor Nazini. Just to speed up, I'll just take you straight to the paragraph, if I may. This is under the heading Issue Estoppel and Abuse of Process arising from previous enforcement proceedings. The role of the court at the seat of the arbitration is different from that of a court in enforcement proceedings.
Sorry, just give me a...
Yes, sorry, 4412. The role of the court at the seat of the arbitration is different from that of a court in enforcement proceedings. The court at the seat has supervisory jurisdiction in that it can entertain an application to set aside the award. If the award is set aside, the parties are no longer bound by it. the arbitrator ceased to be functi officio, and depending on the ground on which the award was set aside, fresh proceedings may start to determine the same dispute that was not validly determined in the previous arbitration. The setting aside of the award provides the successful applicant with a ground to oppose enforcement under Article 5.1e of the New York Convention. An enforcement court has a more limited role. It determines whether the award should be enforced in its jurisdiction. If the respondent establishes a ground for refusal under Article 5 of the Convention, the enforcement court may refuse to enforce the award, but the award continues to be legally binding on the parties. The arbitrators continue to be functi officio, and generally speaking, new arbitral proceedings cannot start afresh. Article 5 of the New York Convention is silent on the effect of a decision not to enforce the award in further enforcement proceedings, and the natural inference must therefore be that such a decision, unlike a judgment setting aside the award, is no ground for refusing enforcement in other jurisdictions.
Can I just ask a quick question on the first part of that? How does the UKOS case fit within that? So
the UKOS case is a refusal by this court to recognize a Russian setting aside.
Yeah, so Russia, it was the seat.
Russia seat.
Yeah, so they have, the court has set aside.
Set it aside, and a party comes to the award creditor, comes to England and says, under our rules of private international law, don't recognize that Russian judgment is corrupt. And therefore, if you take that out of the equation, we have an award which you can enforce.
Right.
Still trying to enforce it now, as far as I know,
yes.
aren't they?
Yes. Yes, all over the world.
So, I mean, when it says if the award is set aside, the parties are no longer bound by it, in a sense that to an extent begs a question about what's happening in a particular jurisdiction if you do take the award and say, ignore the decision of the court. I
think the assumption here is the architecture working properly without corrupt courts.
Right.
And that's the basic structure. So the basic structure is, if it's set aside, it doesn't exist anymore. You have to overlay private international law considerations in each country if they're not going to recognize a particular judgment.
Right.
Doesn't change the architecture of the New York Convention. It just means in your instant case, you've got a corruption, which means that when you're putting it into the formula,
you ignore that bit of the effect. Right. Yeah. But that, as you say, that is a sort of overlay or something more fundamental in terms of the operation of the rules of public international law.
Yes, but
at the level of whether, in that case, our courts would even recognise what has happened overseas as the action of a court, properly speaking.
But it's foreshadowed in Article 5 of the New York Convention because of the word may.
Right, okay. So the may preserves the...
So the may is page 3843. As ever in these fields, there's an awful lot written about one word, and may has generated a huge amount over the years. But there is a discretion recognised, may, and that means, and of course, going back to the point that I had made previously about having to get sovereigns on board, they had to have that let out.
Yes, but so strictly speaking, formally, the word may is significant because it preserves to the contracting states the power of their courts to apply what I was saying were the more fundamental rules of public international law for the courts of that jurisdiction.
Yes.
All right, thank you.
Could you give us at some point the reference to the UKOS case?
Yes.
That you mentioned a few times.
Yeah. It's 2652.
Thank you.
There's also the Malicorp. We also have one other example in the bundle, which is the Malicorp case involving Egypt.
Oh, yeah.
Which is also a similar point. Again, non-recognition because of corruption abroad. 2045.
2045.
Yes.
Thank you.
If I can just take you to now away from the commentaries to some authorities. So we've got the Court of Appeal in Dalla as one example, and that is at 1335.
Sorry, an example of what?
A judicial a reference by a court to the distinction between seat and enforcement.
Yep.
So this is the Court of Appeal in the Dalla case, which was then upheld by the Supreme Court, page 1335, paragraph 16 and 17. This is in the judgment of Lord Justice Morbig. 16, the language of section 1032 of the Arbitration Act follows very closely that of Article 5.1 of the Convention, although in some respects its structure is slightly different. Sorry, just to pause, this was a New York Convention application before the courts for recognition enforcement. And then down to paragraph 17, Article 5.1e and sections 103.2.4 both recognize that the courts of the country in which or under the law of which the award was made have a supervisory role. The scope of the supervisory court's powers and therefore the extent of that role varies in accordance with its own domestic law, but will normally include the power to set aside the award in cases where the arbitral process has failed to conform to the terms of the arbitration agreement or has failed to meet certain basic standards of fairness. In some jurisdictions, notably our own, the court also has the power to entertain a challenge to the award on the grounds of an error of law. The power of the supervising court to annul the award is therefore of a substantive nature. It extends beyond the mere refusal to recognize or enforce the award, which is the limit of the powers available to courts of other states that are parties to the Convention. I had just randomly in my note just come across a reference that I had been asked for. My Lord had asked me for the reference of the PT First Media case in Singapore, which is the one that doubts issue estoppel.
This is Justice Menendez.
Yeah, and it is, the case begins at 3433, and it is paragraph 77 at 3453. My Lords, my Lady, that is dealing with now, I've dealt with one side of my graphic, which is the role of the supervisory court. Can I... I see. I have to correct one other reference. The UKOS case reference is 2639. They're two UKOS cases. Can I now switch to the other side of my graphic and look at the New York Convention in contrast to what I've shown you under the English Arbitration Act?
Completely my fault. I didn't write down the Singapore court reference.
Yes,
Give it.
so the reference is, it's 3453.
Thank you very much.
Paragraph 77. And it talks about the erga omnes effect intended at setting aside compared to the New York Convention. And then it asks the question, how can you have issue estoppel?
Right.
Yeah.
So in a certain sense, I think the Chief Justice analysis would be sort of leveraging off the supervising effect of the
correct
court of the seat and saying it goes this,
but not further,
but not the other way around.
Yeah.
And I think you, sorry to pursue this, but I think you told us you yourself in your submissions would not support that analysis.
No, and the reason is the travaux of, primarily, the travaux of the New York Convention, and the fact that it was almost precisely the effect was rejected when when double control was established.
Yes, thank you.
I mean, I'm reminded that none of this really impacts, for our purposes.
No, we don't have to go there in this case.
No.
That's another case. Can I quickly then just take you through the provisions in your convention? I've referred to them sporadically, but just to do this a bit more methodically. So we now switch to the other side of my graphic, the limited scope of recognition and enforcement. New York Convention is at 3841. The New York Convention does two things, despite it has famously an incorrect title, because it talks about arbitral awards, but part of it deals with arbitration agreements, and that's Article 2. We're not concerned with that. So just looking now at its treatment of arbitral awards, if I can start at Article 3, which is at page 3842, and I've mentioned this a number of times already. This is the central obligation for contracting states to recognize and enforce awards. it says, each contracting state shall recognise arbitral awards as binding and enforce them in accordance with the rules of procedure of the territory where the award is relied upon under the conditions laid down in the following articles. And that's the point I had referred to earlier about the discretion that is given to each contracting state to implement, interpret, apply the convention in accordance with its own rules of procedure. And if I may just drop an oral footnote, again, that's one of the problems with the Court of Appeal judgment and the judgment of Judge Pelling. It just blows that away. Then, what are the conditions laid down in the following articles? There is Article 4, which follows, and that's simply formal requirements, which you have to satisfy. You have to produce a copy, original copy of the award and the arbitration agreement. And then you get to the important Article 5, just down the page, which I've spoken about at length. And this has the same grounds of complaint as, for example, Section 67 and 68 of the 1996 Act. If you scan down Article 5, you are looking at complaints about the agreement not being valid, about lack of proper notice of the arbitration proceedings or the constitution of the tribunal, inability to present one's case, lack of jurisdiction, the award, etc. So it's the same ground. And if you recall my reference to the on-site trial model law, it's the same grounds. 34.
Articles 34 and 36.
36, correct. And then Article 5(1)(e) is the one which has a reference to the country under which the award was made. That's the seat. So 5(1)(e) has a defence. The award has not yet become binding on the parties or has been set aside or suspended by a competent authority of the country in which or under the law of which that award was made. You will note that there's no reference here to a fellow recognising and enforcing court. It's only the courts of the seat. And then 5(2) is the second group of defences that I'd identified earlier. Recognition and enforcement of an arbitral award may also be refused if the competent authority in the country where recognition and enforcement is sought finds that, and then the difference is not capable of settlement by arbitration or would be contrary to public policy of that country. So again, from the chapeau one can see this doesn't have to be raised by a party, this is raised by the court itself. And we see instantly then that the convention refers to two different competent authorities. It's got the competent authority in 5(1)(e), which is at the courts of the seat, and it's got the competent authority where recognition and enforcement is sought. And this just goes back to double control. And of course, in this case, we are concerned with 5(2) A and B, arbitrability and public policy, because it's my client's case that what the award is contrary to Pakistan public policy and not arbitral under Pakistan law. And then just to finish off, Article 6 is a reference to the availability to suspend, to adjourn proceedings for the purposes of Article 5(1)(e) if there are proceedings still pending at the seat. Again, there's no reference to proceedings pending in another court of recognition and enforcement, because that's not going to have any impact.
I mean, yes, in effect, Article 6 is saying, since Article 5(1)(e) identifies clearly that a decision of the court of the seat to set aside, for example, is a relevant consideration for a receiving court. If you're the receiving court, wait to see whether that relevant consideration comes to fruition or not.
Right. Can I then take you to some travaux of the on-site trial model law on double control? So I've shown you now the two different sides of my graphic. And you'll note that there's nothing in the New York Convention which gives you a remedy of setting aside or anything like 67, 68, or 69, of course. So I've explained to you the Article 34 and 36 of the UNCITRAL model law. Two references in the Travo which just describe this issue of how they sit together. Can I take you, please, to firstly, the model law itself is, the relevant Article 34 and 36 is at 3860. That's where you'll see Chapter 7, recourse against award, and there's Article 34, application for setting aside as exclusive recourse against arbitral award. And you'll see there, if you scan down the grounds, they're the same grounds, procedural errors and excesses of jurisdiction. And then if you go further down to page 3861, there's a heading, recognition and enforcement of awards, which is a different chapter. And then you'll find Article 36, and that's on page 3862. And you'll see it replicates Article 5 in your convention. It's the same grounds.
Plus the extra ground corresponding to E.
Yes, yes. Can I then ask you to go to 3929? This is now in the Travo of the UNCITRAL model law. This is a March 1985 analytical commentary on the draft text. And this is discussing Article 36 and grounds for refusal. If you please go to 3938.
Yes. Thank you.
There's, at the bottom of the page, after references, there's a heading commentary. And the heading is grounds for refusing recognition or enforcement of international awards. Paragraph 1, based on the prevailing policy considerations stated above, Article 36.1 adopts almost literally the well-known grounds set forth in Article 5 of the 1958 New York Convention and declares them as applicable to refusal of recognition or enforcement of all awards, irrespective of where they were made. And then if you go down to paragraph 3 over the page, that's 3939. The list of reasons seems also appropriate for domestic awards, although its correspondence with the grounds for setting aside entails the potential of what has been referred to as undesirable double control, i.e. two occasions for judicial review of the same grounds. This should be an acceptable consequence of the uniform treatment of all awards, based on the policy of reducing the relevance of the place of arbitration, in view of the different purposes and effects of setting aside and of invoking grounds for refusal of recognition or enforcement. A party should be free to avail himself of the alternative system of defenses, as such recognized by the 1958 New York Convention, also in those cases where recognition or enforcement happens to be sought in the state where the arbitration took place. As regards the potential risk of double procedures on the same grounds, it's submitted that these concerns are essentially met by paragraph 2, etc. So it shows you the flavor of this, this problem of double control has been there throughout, and it's always been dealt with in the way that I've identified.
And do we have the page reference for see below para 5? Oh, is that literally at the bottom of the page?
That's suspension of recognition enforcement. That's at the bottom of the page.
So just to be clear, whose commentary is this?
This is commentary from the Secretariat, the UNCITRAL Secretariat.
During the drafting process?
Yes, yes. It's March, 25th of March 1985, and later that year then the text was finalized. And another example of this, at 3940, you see the UN report of the working group that was tasked with drafting. This is now just a few weeks earlier, 6th of March, 1985, 3940. And at 3945, paragraph 153, the working group considered a proposal to insert, after paragraph 2, a new paragraph as follows. if an application for setting aside the award has not been made within the time limit prescribed in Article 34, the party against whom recognition or enforcement thereafter is sought may not raise any other objections than those referred to in this article. So that was, just pausing if I can insert some submission, that was an idea on how to do double control by saying, well, why don't you say that you can't go for recognition and enforcement unless and until you've actually gone to the seat.
Well, except in this article, paragraph 1, subparagraph say, well, it's not...
Not all of them.
Not all of them.
Not all of
some
them.
Of them.
Some of them. And the reason why some of them, because there was huge sensitivity about public policy and arbitrability, which came in the second group. But then if you go down to 154, on the same page, the prevailing view, however, was not to adopt such a provision. It was pointed out that the intended preclusion unduly restricted the freedom of a party to decide on how to raise its objections. In view of the different purposes and effects of setting aside and of invoking grounds for refusal of recognition or enforcement, a party should be free to avail itself of the alternative system of defences which was recognised by the 1958 New York Convention and should be maintained in the model law. Yeah, so it's rejected. Importantly, in this system of double control, it's recognised, in particular, it's recognised everywhere, but also it's been recognised by the Supreme Court in England. The seat is not given primacy over these grounds. So we see the same grounds for setting aside and for recognition enforcement. The seat is not given primacy. Can I take you to Dalla, please, on this? Because that was an argument that was put forward in Dalla and rejected by both the Court of Appeal and the Supreme Court. So firstly, in the Court of Appeal, at Dalla at 1336, this is the judgment again of Lord Justice Morbig, paragraph 18. You have that?
Yes.
Miss Heilbronn submitted that the distinction between the powers of the... So I'm sorry, just to remind you, this is a New York Convention application in Dalla.
For recognition.
Recognition and enforcement, yes. So just to... yes, so that's just to position this. Miss Heilbronn submitted that the distinction between the powers of the supervisory court and the powers of enforcing courts naturally points to the conclusion that as a matter of policy, the Convention accords primacy to the supervisory court. In one sense, that is not controversial, because Article 5.1e itself recognises that the supervisory court has the power to set aside or suspend the award, a step which of itself entitles, but does not require, courts of other jurisdictions to refuse enforcement. However, there is nothing in the Convention to suggest that the supervisory court is intended to have primacy in the sense that enforcing courts are expected, much less required, to treat the award as valid and binding unless and until successfully challenged in the supervisory court. If that had been intended, Article 5.1 would have taken a very different form. In particular, it would not have given courts of other jurisdictions an unrestricted power to refuse enforcement in cases where defects in the arbitral process of the kind which it describes could be proved. On the contrary, it's well established, and indeed was common ground, that a person against whom an award has been made is not bound to challenge it before the supervisory court in order to challenge its enforcement in another jurisdiction. See Svenska, and the cases there cited. In my view, the terms of Article 5.1 read as a whole amply bear out submissions, Mr. Landau, that one of the fundamental principles enshrined in the Convention is that such a person is entitled to oppose the enforcement of an award on the grounds that it's not based on a valid arbitration agreement to arbitrate. So I'm showing you this to show that you've got grounds available for seat and for enforcement. The policy is the seat doesn't have primacy on that. And again, the Court of Appeal has given effectively primacy to the seat by saying whatever is available, if you choose a London seat, whatever is available or not available under your convention is conditioned through the prism of what's acceptable in England. And that is just not this structure.
It does make you wonder what the point of this convention is. It doesn't seem to have much function or help a litigant unless usually it works okay and you get your award and you can then take it. Because you can choose the seat of the arbitration you can't really choose where you're going to enforce it, because you have to try and enforce it somewhere where the debtor has assets. So, but if they can just raise all these points again, it does make me wonder what the value of this is.
Malady, can I quote paragraph 126 of ENCA? And these are the words of my Lord Legate and Lord Hamblin, they were quoting Redfern and Hunter, Vetter and Lord Mustill. And what they said in that judgment was, the New York Convention is, and I'm quoting now, the single most important pillar on which the edifice of international arbitration rests, and perhaps the most effective instance of international legislation in the entire history of commercial law. That's ENCA. The reason that was said, I would, in my submission, is because it is the single most successful private international law convention. It has 172 contracting states. What we're dealing with here are the odd cases where something crops up, but there's a massive activity out there of people who agree to a seat in a New York Convention jurisdiction, and then, unlike judgments, they have the benefit to take that award through 171 other countries around the world and get effectively summary recognition and enforcement. And it usually works. It usually works. And it's working. I mean, it's not to say it's not working in these cases. This is what it was designed to do. It's designed to pick up awards that shouldn't be enforced. There's a misconception. People say, and my learned friend says often in his written submission, about the policy of being pro-arbitration. The policy of pro-arbitration is not enforce every award, because some awards do not merit enforcement. And the New York Convention has a perfect balance on that. And as I said before, we have still struggled in the world of judgments to have anything like the New York Convention. It's the reason, it's often stated, it's one of the reasons why people choose arbitration in the first place, is because they have the New York Convention, which you only have for arbitration. I know we're pressing time. Can I just give you take you just to Dalla in the Supreme Court?
Yes.
And then that might be a convenient moment.
I mean, Dalla illustrates your point. It's another case where the English court decided the award wasn't valid, I think, and refused to enforce it, but actually the court of the seat, the French, decided it was. It's another Kababji case, isn't it? It's
part of the same rich tradition. And can I say that in arguing Dalla under the New York Convention, there was never a suggestion that the court should apply French law to interpret the treaty. It's an English question. So just to take you to the Supreme Court in Dalla, 1398. This is in the judgment of Lord Collins at paragraph 103, bottom of the page. Nor is there anything to support Dalla's theory that the New York Convention accords primacy to the courts of the arbitral seat, in the sense that the supervisory court should be the only court entitled to carry out a rehearing of the issue of the existence of a valid arbitration agreement, and that the exclusivity of the supervisory court in this regard ensures uniformity of application of the Convention. There's nothing in the Convention which imposes an obligation on a party seeking to resist an award on the ground of the non-existence of the arbitration agreement to challenge the award before the courts of the seat. So you can go off and do whatever is available for you. Rather than going before the courts of the seat, you can go to a New York Convention country and do whatever's available for you there under the New York Convention, as long as it's not encroaching across the line.
Which I think was the point made in the second of the commentaries that you showed us.
Yes. And I wonder whether I could just leave you with one further follow-up point. It's said against me about Dalla that Dalla had in mind two options, which is sometimes called a choice of remedies. The choice of remedies is if you are a losing party in arbitration, you can either take an active remedy at the seat and apply to set aside, for example, under Section 67 or 68, or you step back and you can resist recognition and enforcement wherever that's sought under the New York Convention. And what they say is that we are not doing that in this case. We're doing something different, because they say we are going preemptively now for non-recognition, declaration of non-recognition in Pakistan. I just want to clear away this point. As we've said in our written case, and after lunch, if it's not a disincentive, I will address this. Our application in Pakistan is not preemptive. It is an application for recognition, partial recognition and enforcement, albeit along with that is non-recognition and non-enforcement. So it's not preemptive. But assume it is preemptive against me. As Germany shows from the Pelling case, different countries have different implementations of the New York Convention. And many countries, including Germany, for more than 60 years, allows a preemptive application under the New York Convention for a declaration of non-recognition and something is non-recognizable or non-enforceable. That remains a remedy that's available under the New York Convention. So this choice of remedies doesn't mean we can't do what we're doing if it is preemptive. It just means it depends on the local law, how they've implemented the New York Convention. And that's, again, the mistake of the Court of Appeal, which is to say, no, they're not allowed to do that because you look through the prism of English law. My lords, my lady, that may be a convenient moment.
Yes. So I'm just looking at the timetable.
Yes.
I think if you use up the stenographer breaks today,
yes,
and your opponent uses them up tomorrow,
yes,
that's a fair distribution of stenographer breaks between you, if you're happy with that.
Yes.
By all means, come back and say that that doesn't work, but I think it does. Very well. We'll adjourn now. Resume at 2 o'clock, please.